All right, we're back on the record. Civil Hall versus Lindsay Partin, CR 18030462. We have all attorneys and parties present. We have concluded the testimony in front of the jury for the day. Ms. Howard or Mr. Fagan, I don't really care who answers the question, but at this point, does the defense anticipate calling any more witnesses when we resume tomorrow?
No.
No, subject to the admission of evidence, we'll give the rest.
All right. So, prosecutors, the defense has rested. We're going to go through the defense evidence list at this point to determine what has been admitted, what needs to be admitted,
Don't
and so
put stuff over
forth.
here. I have a system.
So, defense, I will let you folks take the lead based
Okay.
on the list that I have. Prosecutors, let me know if there's any discrepancies. Ms. Wilson, if you need us to slow down, et cetera. But, all right, defense, go ahead.
I had intended to, do you want me to go line by line, or do you want me to tell you the ones I believe are admitted?
I don't really
No,
care.
they were going to move for admission.
Okay, well, I moved for admission before I demonstrated to the jury.
Let's start line by line. Let's start
Okay.
with
A was identified but not admitted.
A. And you're not seeking it to be.
No, it's a partial transcript that was used for cross-examination.
All right, very good.
B was identified but not admitted. It's an email of Dr. Correa.
Not admitted?
You didn't show her that.
No, it was not admitted.
Okay.
Okay, hold on just a second. So B, okay, I'm sorry, go ahead.
C as in cat was identified but not admitted.
Okay,
D as in dog was identified but not admitted.
all right.
E, I think, is actually, it was
In the state's
admitted.
case,
It was in the state's case, okay, that's why I don't have it. So I didn't identify it either. F was identified but not admitted.
All right,
G was identified and admitted today.
Yeah.
H was identified but not admitted. I was identified but not admitted.
all right.
J, 1 through 13, which are photographs, were both identified and admitted through Detective Lambert.
That's what I'm showing as well, State.
Yes.
All right,
Did you show this?
I just used it to cross-examine.
K was identified for purposes of cross-examination, and I believe it's contained, it's an excerpt of the Children's Hospital records.
all right. So separately as K, it is not being admitted.
Correct.
Very good.
L was identified but not admitted.
Very good.
M was identified and we seek its admission. That's the CV of Dr. Spitz.
State.
I'm sorry, I got behind flipping the page. L is a no, right?
Correct.
And then the CV of Dr. Spitz, no
Correct.
objection.
M will be admitted.
We don't need the rest.
N was identified and we seek its admission.
Object.
Oh, don't tell me, don't.
All right, this is that
No,
list that he identified as being a list of trials that he
Withdraw.
participated in.
Yeah.
State was the basis of the objection.
It's the trials and depositions of Dr. Spitz, where he's previously testified. He testified on his own that he testified before. An entire list of his trials and depositions is not necessary, it's cumulative. If we were gonna do that, I would have had all my experts prepare a list of every trial they've ever testified. It doesn't really go to their expert qualifications, the CV does.
Well, it does go to the expert qualifications, but I don't think, unless you care to overrule me.
I was just looking for the CVs of the doctors that the prosecutor identified and see if there's included such things.
Why don't we table that and go on? And then we'll go back.
Well, no, I actually don't want Miss.
I'm almost finished. I found the exhibits.
I don't want Miss Howard's attention distracted there while we're moving on.
I'll just let you rule on that. I don't see that they've included trials and depositions within their CVs.
All right, that being the case, then I'll deny the admission.
O was identified and not sought to be admitted. It's a report just like the prosecutor's reports.
Very good.
P was identified but is not sought admission.
All right,
Same for Q, identified but not sought admission.
okay,
R was identified but not sought admission.
all right,
S was identified but not sought admission.
all right,
T1 and T2 were both identified but were not sought admission.
Okay,
U was identified but not sought admission.
okay,
V was identified but not sought admission.
all right.
W was identified and was admitted today.
I'm showing it was admitted today as well. Okay,
Um,
X.
X was not identified.
All right,
Y was identified and was admitted. Through Jason Weshy.
and state your list is reflecting those.
Can I see those? Sure. Why? Is it 1 through 5, right? No objection.
All right, I do remember Mr. Weshy testifying about those, and I do think that we had already.
I think they were actually admitted at that
Yeah,
time.
They were.
believe
Okay.
I just want-
I
I just want
published
the
them.
state to satisfy itself
Okay.
it was the same photograph, so, okay. Why, the 1 through 5 photographs have been.
Z, 1 through 6 was identified and published and admitted already.
That's what I'm showing through again, Mr. Weshy.
And I have a separate line for Z7. I had questions on it, we had a ruling at the bench. I'd like it preserved for the record.
Identified, request for admission, request denied, preserved for record.
Double A were photos, and those were identified and admitted. Those are double A.
All right?
Okay, can we stop for just a second? I just want to make sure,
No,
because
no,
I've,
No, take your time.
so, there's your J's.
No, J's were all together, did you?
No, I did, they were actually with this one, so those J
It's all of the J's.
1 through 13, okay.
All of the J's.
And they ended up stuck with the Z's, that's why.
Okay,
So Z1,
here's the J's.
2, 3,
Ms. Olson, are you keeping up with the record reading?
I am,
6. So these are the Z's.
Very good.
I just want to make sure Z7 was identified but not admitted, correct?
Those,
Correct.
I think the suitcase, with the J's, that they ended up stuck with the
That
others.
is the
Okay.
recreational aid.
Huh?
Oh, you didn't get to see it down there.
So 7 is just preserved. And Judge, I know the state, I don't know if it's the same process here. I know that you had the state, anything that was identified, you had us provide to the court for the record.
I have a
Since it was
second.
that, okay. So,
Now, with some exceptions, the physical train, we're
Right.
not intending to take the physical custody of, and I can't wait to hear the defense position on SS-1. Don't ruin the surprise.
I'm looking forward to it.
I'll formulate it by the time we get to that, we're
Alright.
far from it.
So I'm then back on, I think, Ms. Hiley was reviewing double A.
Double A's.
22.
Yes. Here you go.
State concurs, those were the
Yes.
ones previously admitted. Very good. Okay, so we're on double B.
B was identified,
Double B,
I'm sorry, double B was identified and admitted.
correct.
Double C was identified and admitted.
Correct.
Double D was identified and admitted.
Correct.
Double E was identified and admitted.
Correct.
Double F was identified and admitted.
Correct.
G was not offered. I'm sorry, double G was not offered.
Not identified even?
I still had it in my folder, so,
I don't have it identified.
I don't either. I was going on the notes I was writing out yesterday.
this was from today. This would have come today.
Okay, then I would have marked the list that you gave me if we had added today. so.
What number were we on?
Double G.
No, it was
I don't
not.
remember seeing that one.
It wasn't, it's still in my folder.
All right, double G, not identified nor admitted, very good, okay. Double H,
Double H was identified and admitted.
that's what I have, yes.
Double I through double P were neither identified, so obviously not admitted.
Okay, now I'm showing double K was.
I am too.
Let me see where that's at.
Both identified and admitted.
You're correct, it's not in the spec 3 at least.
Stage, you need a moment to
So it's up
confirm
here.
with what you are showing?
Let me find it.
Yes, this was the one about the dance.
Ah,
That
okay.
was the one about the dance.
So double K, yes, identified as admitted. Double L for double P, correct, not identified as admitted.
Okay, I'll have to find that one that's not in here.
All right, next.
Double R, I show identified and,
Double Q.
I'm sorry, double Q was transcript, it was identified but not admitted.
That's what I should. All right.
Double R was identified and I show admitted.
And state concurs.
Double R, we're talking about the first 5 pages of the extraction report?
Yes,
Yes,
Yeah, I'm showing that we did that yesterday.
correct, with detective entry.
yes.
All right, very good.
Okay.
Yes. I'm just trying to figure out if Erica's gonna send you a Christmas card or not.
That'd be a lot cheaper to send me a Christmas card than me to haul those back boxes away.
It's up to you.
These trees had to die for a reason.
I know. Wasn't happy. Tired. They were identified.
Correct.
What letter was your disc? Or, I'm sorry, what number?
125?
Yeah, that's what I was thinking.
I said that wrong. Yes, 125.
Okay, thank you. I won't seek their admission.
What number is it?
That would be all of,
SS1 through SS8.
inclusive of SS1A and SS1B.
The boxes that cause the domestic relations court some consternation.
They're identified but not admitted?
Correct, yes. Now, similar to the physical train, unless somebody is requesting to retain the boxes, I am not inclined to do such.
I'll have to have my delivery boy come get them.
I think it's a good plan. The exercise doesn't good.
And that's not in Mr. Pagan, by the way.
I know, I paid had nothing to do with
Obviously, you had trouble lifting the one box.
it. Record reflect that that's not true.
Double T was the flash drive video deposition of Dr. Spitz.
All right, now here's where I just want to make sure that this gets clear. The flash drive that was played was provided to me by the state. I asked that the defense mark it because it was A, their witness.
Okay.
B, a flash drive is going in, since we did have questions of objections that I ruled on in another hearing and so forth. I want to preserve those for appellate review. Does the parties agree that the version that was played be the one that is submitted for appellate review, even though it technically was in the custody of the state?
Oh, absolutely. It is what was played, so I think is what should go in. And I think we made a record at the last hearing about where the excerpts came out.
Correct.
And I would state for the record that based on my listening, I don't think anything that the court had ruled out was played. I didn't hear anything that caused me concern.
No, and I will say, based on my notations and following along in the transcript, I get all of the marks actually presently perfectly. I was surprised. So,
I can't see why we would object to that one.
okay. So the flash drive that I do have, if you folks have a sticker, Jamie, if you have a sticker, either way, it will be identified and marked as defense double T. Will not be admitted, but it was. It has been published to the jury under Criminal Rule 15 under depositions in a manner consistent with the civil rules of evidence as required. Thank you. And I'm showing that's all the defense exhibits, is that accurate?
That is correct, Your Honor.
There's one last point, and that is, you made a ruling about Dr. Makaroff's opinions being within the opinion letter, and then we preserved the objection. And I'd like Dr. Makaroff's opinion letter to be preserved in the appellate record for that issue.
Hold on, sir.
I think they're there already.
It may have already been, what was the state's exhibit?
Yeah, so I think there
That
were like
was-
6 exhibits.
Was that in 40?
The report,
No, yes, it was
Yes.
her letter, would it be her supplemental?
the supplemental was 40, the
Yes.
regular report was 39, is what I
So-
got.
40 has been identified, 40 has not been admitted, but since it's been identified, it will be submitted as part of the record, as all other identified exhibits.
So I would just ask that 40 go in, not to the jury, but in the
Well, that's
record.
what I'm saying, yes.
Yeah.
It will be preserved as part of the appellate record, yes.
Do you have a copy? Where's the copy?
No, it's all right, so everything that we identified yesterday, we already put together, and the court has those exhibits that we identified but did not admit to maintain them as part of the record.
All
So
those
they
will
are
be
in.
retained for appellate purposes. The only exceptions are the physical training and the 22 boxes of records.
Ms. Sheehan, you did take the envelope of identified but
I
not
put it over there.
admitted.
Yes, whenever you identify in cross, should also go in, even if not admitted.
Threw everything over here, so let's see if we can find it.
Yes, they're right here.
So we have concurrent, we all agree. In terms of what has been admitted and any subsequent rulings in terms of the defense exhibits, correct?
Correct.
Very good. All right, defense, anything else that you wish to address before we press on?
We renew our Rule 29.
Again, submitting.
Yeah, I'll
Okay.
I'll submit.
All right, once again, based on the testimony that the court has heard during both the state's case in chief and the defense case, after having also considered all of the previously admitted exhibits both on behalf of the state and the defense, and looking at said evidence in light most favorable to the non-moving party of the state of Ohio, the Rule 29 motion will be denied as the court does find that there is evidence that would be sufficient as to each element of all the charges presented, but preserving the rule thereof. Anything else?
Would you like to have a conference on jury instructions?
If there's nothing else to address, I think that should be our next step. Yes. You guys want to go out here, you want to go in the back? I don't think that would be
Go
easier.
back and sit down and start out.
Good, because that'll allow you to share.
And maybe it's today or some other day.
It's here. Never mind.
But honestly, I don't really anticipate coming back on the record. If we have any issues that need to be addressed on the record in terms of jury instructions, we can do that first thing. Okay? So, folks in the back, that means that we are going to go back and discuss jury instructions. We're going to go off the record for the evening. You all are free to go home. Miss Wilson here is double T.